Okay, it is 9 o'clock and welcome to an oral argument session of the 5th District Court of Appeal. We have one case on the docket this morning at 9 o'clock. But before we go further, I would like to introduce myself and the panel. My name is Rand Wallace. I am currently living in Seminole County, Florida, and joining me on the panel today we have Judge Eric Eisnagel also from Seminole County, and we have the privilege of having, for the first time ever in an oral argument session for the 5th District Court of Appeal, Judge Carrie Ann Wozniak. And I want to welcome Judge Wozniak in the first public forum for this court. We're very excited that she is joining us now as a judge on our court. And we're going to be moving forward with the Wilson versus State of Florida case. And counsel, I'm going to assume the appellant wants 5 minutes of rebuttal unless you tell me differently, and just ask for everyone to make sure that you've got any noise making devices. If you would put them on mute so they do not interrupt the lawyers. I am going to mute mine right now. And with that, Mr. Foreman, you may begin.
Thank you. Good morning. May it please the court. My name is Jason Foreman and I represent the appellant, and the 5 minutes of rebuttal time would be sufficient. Thank you. As the court knows, this post-conviction relief case involves a 14-year-old teenager who was the alleged victim of a sexual battery by digital penetration. The focal point of the trial was the injuries to the teenager's vaginal area that was purportedly inflicted by the appellant. Now, the state's theory of the case, of course, was that the injuries were as a result of the sexual battery, and defense counsel's theory was that the injuries were self-inflicted from scratching due to the teenager's medical issues, specifically a bad yeast infection that she was having recurring problems with. Now, at trial, the state called a very effective and tough witness who was adamant that the teenager was the victim of sexual abuse and that the wounds were not self-inflicted. Now, defense counsel did not call an expert, and as explained in the briefs, that was due to negligence more so than a strategic decision, and I'll talk about that in a little bit. But this case is actually a little bit different than most post-conviction cases because it's actually one of those rare cases where both the deficiency prong and the prejudice prong is met. Normally, if there's an issue, then the deficiency prong may be met, but the prejudice component is the most difficult. And counsel admitted to several things at the evidentiary hearing that demonstrate he was deficient. I truly believe the only question, if it's even a question at all, is the prejudice. And I'd like to talk about the prejudice prong briefly. I did file a notice of supplemental authority, I believe it was last week, BOTO, which is a decision from this honorable court, where the court found, and I'll give the site, I assume the court has it, but I'll give the site anyway, 307 Southern 3rd 1006. It's a December 2020 case where the victim was, or the child was a victim of sexual battery. It involved a Williams Rule violation. There was 2 Williams Rule witnesses. There was a CPT interview. The trial court found that the evidence was overwhelming, or rather the post-conviction court found that. This court went on to say that the trial deprived the defendant of a fundamentally fair proceeding and a reliable proceeding. Because normally, or at least the language of the prejudice prong of Strickland says that you have to show that there was a reasonable probability that the outcome would have been different. But we know Strickland doesn't actually require that showing, that but-for type of showing. There just has to be some sort of a demonstration that the trial was fundamentally unfair, that it wasn't reliable.
Counsel, what's your strongest argument that there was prejudice?
As far as a particular issue, or?
Yes, this case. What's your strongest argument? You make a lot of arguments.
I do.
In your brief, can you sort of pinpoint one or a combination of one or two that you think is really pivotal?
Yes. Well, again, the entire case focused on the injuries. So, I mean, I truly believe that a lot of them are even by themselves are sufficient. But The opinion by the expert that the child was, or the teenager was a victim of sexual abuse, I think was highly improper under the facts of this case because of the age of the teenager. Under the case law, even from the Smith case from this honorable court, age is a huge factor in determining whether or not the expert testimony should have been admitted.
Age is not, Mr. Foreman, age is not the bright line rule. Is that correct?
That is correct. And I believe every case is truly different, but what the courts indicated in Smith and Glendenberg, they talked about the age. And especially Smith said right off the bat that basically because of the age of the teenager in Smith, that it's not helpful. So we could kind of infer, although I think it's more than inferred, it's suggested that the age is a critical factor along with whether or not it's prejudicial.
Well, Mr. Foreman, wasn't there a lot of probative value in what the expert said there? Like, I'm struggling with whether, 403 would have come into play there, because I know the expert said here that usually there's physical evidence of abuse only in 5% of cases. And the fact that she thought that she saw it here, that seemed really probative to me.
And I understand it's certainly a reasonable interpretation to say it's probative, but if you look at the totality of the case here, where there was an alternative explanation, the self-scratching, and granted, I believe that counsel had issues with that, but basically the injuries occurred in two ways: by digital penetration, by the appellant, or self-scratch. Either way, it was by a fingernail purportedly. So in this particular case, it's not probative because basically all the expert is doing is vouching for the victim, bolstering the victim, saying, yes, this is what she said, so it must be because of that.
Well, I think she testified that the injuries were in different places. If it was self-scratching versus if it happened like through an assault, that it would be in different places as well.
Correct. But the way and the manner in this particular case where the teenager was able to articulate what happened, she told the CPT interviewer, which wasn't presented at court, the CPT interview. She told the law enforcement, she told the teacher, she told her grandfather. She told everybody what happened. It wasn't probative because all it was doing was vouching for the credibility of the victim. But obviously, let's assume that for the sake of argument that was permissible. The peer review testimony certainly was not. Now, normally, when there's a Daubert hearing, a pretrial hearing, we want peer review testimony to show reliability. In front of a jury, we can't have that. It violates the confrontation clause. So initially, the testimony, sometimes during these trials, it's just a bleep. It's just a short passage. Yeah, we do peer review, and then they move on. This particular case, I said, every case is peer reviewed. I've been doing this for 14 years. I've never once had a case that came back to me saying I was wrong. But the most important part of that is how it was used in closing argument. That's really what's the most egregious part here. The whole issue was whether or not these injuries were as a result of abuse or self-inflicted. The jury heard that not only did the expert believe that they were as a result of sexual abuse, but that child abuse pediatricians reviewed it and also agreed.
So, Mr. Foreman, you're the expert for the state is saying it is abuse.
Yes.
Obviously, what you were hoping for, if this had gone the way a textbook defense would have gone, would have been a battle of the experts. Is that correct?
Yes.
Okay, so factually, what evidence are you going to give to your expert that you are then going to believe that the expert is going to use to bolster the opinion that it was some type of yeast infection or self-scratching? Is it the same evidence that was relied upon by the state's expert and just a different interpretation? Or was there anything else there that would have been more of a central focus of the defense?
Well, the mother's testimony was important. That, the defense counsel called the mother to testify to say, one, it didn't happen, and two, my child told me this is what happened as far as the self-scratching, that she was self-scratching the days before. And of course, defense counsel said, hey, listen, I called the mother to testify. I simply forgot to ask her questions about the medical. So right away, that would have been provided, assuming counsel, what he said in opening statement was true. that testimony would have been provided. But defense counsel also didn't call an expert, and the expert, it wasn't really just a matter of interpretation. The expert looked at the photographs, she saw the area of the injuries, and she described what normally happens if there was in fact a yeast infection, talking about pooling where the injuries would be on the bottom, that is consistent with the type of injuries that she had. So it's a combination of the defense expert that was not called because counsel indicated he just forgot, because he forgot to look at the photographs to make a determination as to whether or not an expert needed. The mother's testimony, which he forgot to ask her questions regarding any of the medical testimony. So without that, he really didn't have an opportunity to present about the medical history, other than when the child denied that it happened days before. She said it happened a long time ago. The expert said somewhere that it was disclosed to her that it happened in January, that she went to the ER. This offense took place in April. So we didn't have that evidence. And then of course, defense counsel was relying on the state's expert when he told the jury in opening statement that the state expert was going to say that it was just as likely as a result of self-scratching as from a medical condition. And of course, the expert adamantly denied that. Defense counsel admitted at the evidentiary hearing, she never said that. He just was flat out wrong about that.
Does the defense need to call an expert in every case?
No.
For effective assistance? And so if that's not, if it's no, then what is the line there? What makes it ineffective when there is no expert called?
Okay. The key is the amount of the investigation that is done. The reasonableness of the investigation controls everything as far as whether or not they're deficient. Here, like I said, he told counsel told the trial judge, I had these photographs, or I forgot to look at the photographs to make a determination as to whether or not an expert's needed. So it was out of neglect. All the case law I cited in my brief and obviously the Sixth Amendment, neglect is never a reasonable decision. It always is an unreasonable decision. It's deficient. The question is what prejudice resulted. In this particular case, where it would have been the battle of the experts, this expert said not only was the main laceration just a natural groove, she said basically that there was swelling of the vagina. There was some other issues as well. She saw something that was red that wasn't a bruise. She said the injuries were equally consistent.
So I think you just referenced what's been called in the record the normal variant.
Yes.
Right. I guess, that seems like a substantial argument in your favor, except that didn't that article not come out until long after the trial? That the article that supports the concept of the normal variant?
That is absolutely true. That's what the expert said. Now,
so how? I mean, right. So how? I don't understand how counsel could be ineffective for at least as far as that goes. Now, obviously the bruise is a different issue, right? But at least as far as had he presented this expert, we can't really consider the normal variant part of her testimony because that didn't exist at trial.
That's true. It's a little unclear whether or not she would have testified that way, but for that article. But yes, I agree with the court. But if you look at the totality of her testimony, she talked about the difference between internal and external injuries, about the Department of Justice, what they would consider internal injuries, where the state's expert called these injuries internal, but they weren't, they were just recessed. And that's a big difference because for digital penetration, the way it was described, if it was internal and, a little bit further inside, then that would support the argument as opposed to the self-scratching. So we have that.
Counsel, I'm not suggesting that your expert wouldn't have had value. I'm not suggesting that, but I just want to be clear. You agree that at least on the issue of the normal variant testimony, that we can't consider that when we're doing an evaluation of prejudice here, because your expert at the time of trial could not have testified on that issue in the way she did.
If that's what she conclusively said, then yes. If she relied on that article solely, then yes. If there's any wiggle room at all as far as whether or not she would have discovered
that. You tell us. I mean, that's the way I understood the record, but you tell us.
I think that's a fair interpretation.
Okay.
Okay, I'm not going to dispute that. But again, this isn't just in isolation. This isn't just failing to call an expert. It's not just about, not objecting to peer review testimony, which, by the way, counsel simply thought that it had no effect on the jurors, which obviously case law recognizes the effect it does have on jurors. So the entire case here is focused on the injuries. And we have all these errors. We have defense counsel telling the jury of all this evidence that the state expert is going to present or testify to in his favor. State expert doesn't do that. The state expert gives her opinion as to that the child was a victim, or the teenager was a victim of sexual abuse. He doesn't object to that. It's all of this is presented in closing argument. There's no objection again, even though it was raised initially. He tells the jury, he promises the jury, I don't want to say promise because I didn't use those words, but he tells the jury of all this evidence that's going to come from the mother. He chooses the mother as a witness who's a horrible witness, but he makes a strategic decision, but he executes it so poorly that it can never be deemed reasonable. He forgets to ask her anything about the medical testimony.
Counsel, you agree that just calling, had counsel executed the inquiry of the mother, that just calling the mother would not be unreasonable, correct, given the circumstances?
That's a strategic decision, yes. I would say that it would be deemed a strategic decision.
So you don't take issue with the fact that the mother was called. You take issue with after mother was called with what you consider to be a deficient inquiry, correct?
Well, I actually take issue with both because obviously not executing correctly is a stronger argument for me because it can't be a strategic decision that's reasonable if you don't execute it under Fitzpatrick. But as far as calling her at all, I think was totally unreasonable, but it was a strategic decision, but I believe it was unreasonable because her testimony was not credible. She went up there and said, yes, I pled to child neglect based from the sex abuse charges. She had 4 felonies.
But isn't your argument that she shouldn't have had to say that?
Yes.
Okay.
I guess it plays in. Yes, I guess it's the execution then. But
and she was all that they had, right? She was the only other person there because the defendant wasn't testifying.
Correct. But with all the history, all the time she changed her story, she was never going to come across credible. And that's exactly.
Well, counsel, I mean, look, you're down 6 points and you're on the 50-yard line, right? You have a Hail Mary, do you throw it into the end zone or you take a knee?
Fair enough.
All right. So putting the mother on the stand wasn't ineffective. It was your argument is that the way it was executed was ineffective.
Yes. Which means yes, because that is correct. I mean, failure to ask her any questions about the medical, as well as also the asking her about the fact that she pled to charges related to these charges with this defendant's charged with. I think those two rendered any decision deficient, and then it collectively it falls.
Counsel, on your rebuttal, you have less than 3 minutes left. On your rebuttal, I'm going to ask you about the text message. Do you want to save your time, or?
I'll save my time. Thank you, Your Honor.
Ms. Matthews, you may proceed.
Good morning. May it please the court. My name is Charlene Matthews on behalf of the state of Florida in this case. I would disagree from the outset that the focus of this trial was on the medical testimony of the child's injuries. I think the focus of the trial was actually the victim's testimony. She was articulate, she was a teenager, and she was able to testify to the events that occurred to her. Regarding the failure to call, regarding the medical expert and the expert's rendering of an opinion that the victim was a victim of sexual abuse. I argued in my brief, as the trial court ruled, that evidence was absolutely admissible in trial. This was a medical expert conducting a medical examination and reporting her personal findings, and as well as her professional opinion. She was qualified to do that. she was qualified to conduct the examination and render that opinion, I would.
Well, counsel,
liken-
what should the, I mean, and I think that's a fair question, right? What's the proper opinion here? Is the proper opinion here, yes, there was sexual abuse, or is the proper opinion here, these injuries are consistent with sexual abuse? Or perhaps even go as far as to say there's nothing else that could have caused these injuries other than sexual abuse. Which of those opinions is the proper one?
I believe under Glendending and Bloodworth that the witness was properly allowed to testify that the victim was a victim of sexual abuse. That's her opinion, as as the court in Glendending said, she was qualified to give that opinion, and then the jury was also able to accept it or reject it as they saw fit, but it was clearly admissible evidence. I would liken this to a medical expert who observes a knife wound on a body and is able to render the medical opinion that the victim was stabbed. This is medical testimony. This is not some sort of conjuring up of some sort of opinion based on a statement that the victim has given, or as in the 50 CA's case, I believe it's Smith, where there was absolutely no medical or psychological basis for the expert opinion, that it was just not founded in any sort of science. It was not an expert opinion based on any sort of science or medicine. I would like to move on to the issue of the trial counsel's decision not to call an expert.
How about the peer review counsel? Was that
okay? I'll be glad to jump there first, Your Honor. A lot of times in trial, a trial attorney has to make the split-second decision as to whether or not to object to testimony that came in. Trial counsel testified that he decided not to object because it would have drawn more attention to it. He also, in his opinion, felt that it was not damaging, that it was just someone testifying that her boss reviewed her work, and everyone's got a boss, and people review other people's work.
In this particular case, I mean, I saw this as a credibility contest. And when you're looking at this particular case, without comparing it to Glending and the other cases, when you're saying that the expert was peer reviewed and looked at by others and approved, this opinion was, that seems to really tip the scales in the state's favor and affect the effectiveness of the defense counsel as far as the objection goes. Like he should have objected.
He considered and then declined to. A lot of times you can't unring the bell, and he just made the strategic decision not to object, not to draw attention to
counsel,
it.
What if the testimony had been, yeah, I made this report. Here are my conclusions. It was, in my opinion, definitely sexual abuse, and I've had 5 other experts look at this. They all agree with me.
I think it would have caused more prejudice than in this
why
situation.
Is that? I mean, why is that different than what happened here?
Well, I think it is a matter of degree, Your Honor.
Okay, so I've had 2 other experts look at it. They both agree with me.
Yeah, I think that is more damaging than just saying my work was peer reviewed and my boss agreed with me.
But isn't that what that means? So isn't that what my work was peer reviewed and they agreed with me, whoever it was? Isn't that essentially saying some other expert looked at this and by the way, I'm right?
Trial counsel did acknowledge in the hearing that he probably should have objected to that testimony in hindsight. But hindsight is 20/20 in these matters, and you have to look at then what real prejudice came of it. I feel like that the medical expert was used effectively during cross-examination by trial counsel. He got her to acknowledge that the lacerations, that it was possible to be caused by self-scratching. He was planting a seed of reasonable doubt. Remember, this is not a civil case. Trial counsel didn't have to prove anything. He just has to sow the seeds of reasonable doubt. And he sowed the seeds of reasonable doubt through the medical expert who said, yes, it's possible. This is scratching, self-inflicted scratching. And then he had the victim also acknowledge that she was having difficulties that caused her to itch. So, I think when you look at it as a whole, and
she said it was sexual abuse, and at least one other expert agreed with me, essentially, because of the peer review testimony, right?
Well, she did say that it was peer reviewed.
Right. And wouldn't a reasonable jury understand that to mean, okay, she says it was sexual abuse, and at least one other expert, because she was peer reviewed, agreed with her? Yes or no?
Yes.
Okay.
But we also have her opening up the door to the possibility that it was a self-inflicted injury caused by scratching, and the victim actually corroborating the fact that she had a problem that had caused her to scratch and itch. I also.
So if there's conflicting evidence back to the ultimate conclusion as to whether or not there was sexual abuse, your own expert agreed that it could have gone either way. It's possible either way. Shouldn't that have been a conclusion solely for the jury?
No, I believe that relies upon her expert testimony. She saw the injury. She used her observations and her examination of the injury to answer that question. She could have answered.
How can she reach that conclusion if she concedes that it could be from scratching? On what basis did she reach? On what proper basis did she reach that expert opinion if she concedes that it could have been from scratching?
Well, expert medical opinions don't have to be 100% positive. It's, I think, a reasonable degree of medical certainty. The defense counsel did open the door that it was a possibility. And of course, the expert said not probable at all. But again, this defense attorney is tasked with creating reasonable doubt, and he did that to the best of his ability through having this expert who would not agree on during deposition that it was possible. She did agree during trial. The issue that regarding trial counsel's declining to call an expert, he testified at the evidentiary hearing that if he had wanted to call an expert, he would have done so. He evaluated the need for an expert by looking at what the state's expert would testify to, and he was prepared to use her own testimony to impeach her, and he did that.
What about the failure to just review evidence and admitting the failure to review evidence as a reason why he didn't go forward with hiring an expert? That borders on more, not a strategic decision, but the neglect, as Mr. Foreman touched on.
I believe he said that at trial, if I'm not mistaken. I could be wrong about that. But based on trial counsel's testimony at the hearing, it was a strategic decision. Let me also say that he did depose the state's witness. He knew exactly what the state witness was going to say. He did his due diligence with her. They discussed the testimony. They discussed the photographs, I'm sure. He knew the contents of the contents of her testimony was, not actually laying eyes on the photographs until later.
Counsel, I don't, investigation aside, and I do think that there are some questions, right, on the investigation here, but investigation aside, I'm struggling in a case like this that involves medical expertise outside of the understanding of your average juror, where the state is going to present and frankly a powerful expert, especially the way it went, testifying that not only were the injuries consistent, but this was sexual abuse. I'm struggling to see how not hiring an expert, if you can find one to say, no, it wasn't sexual abuse, here's why this other expert's wrong. I struggle to see how that is a reasonable conclusion, even if the investigation was done. Can you walk us through that?
Well, trial counsel had an alternative theory that he was advancing, and that was that this scratch was self-inflicted by the victim, and the victim corroborated that it was also possible she had a condition that was causing her to scratch. Adding a third theory in, I think sometimes would confuse a jury, number one. Number two, that expert witness.
I'm sorry, counsel, where's the third theory?
The third theory is that there was no injury at all, that it was a natural variant.
No. We're not talking about the natural variant issue. We're talking about the other parts of the expert's testimony regarding the bruise, that it wasn't actually a bruise, things of that nature.
That she would have been effectively cross-examined by the state. Her testimony was based on two-dimensional photographs, and the state's expert then was, at the evidentiary hearing, was presented with the defense expert's findings, and the state expert absolutely said, no, she's wrong. Basically, I saw them myself. The state's expert was not relying on photographs, two-dimensional photographs. I think that.
Okay, so I mean, there would have been, grounds for the state, or the state would have had the ability to attempt to discredit the defense expert by saying, well, you didn't actually, you're only looking at photographs. Our expert actually investigated this one-on-one. Is that enough reason to not call an expert?
I think you have to look at it together. You have to look at all the reasons why he chose not to call an expert.
What are the other reasons?
Well, because he evaluated the need for one, and he decided that he could use the state's own expert and impeach her testimony, which he did.
In other words, his whole strategy was, we're going to hope to tear down the state's expert as far as we can.
Well, I don't think it was. I think it was more than a hope. I think he had a plan. He had a strategy. He asked, pointed and well thought out questions during cross-examination.
Why would you not, even if that's true, why would you not offer your own expert who is going to support your theory of the case, which is that this is just self-scratching?
Well, they didn't present an expert that said that this is just self-scratching. That's not what their expert said at the evidentiary hearing. That's hypothetical. I don't know if they could ever find one to say that.
What did she say about the bruise, counsel? Maybe I misread it.
Well, Judge, if you have a page number, I will refer to it.
That's okay, counsel. I'll go and reread it to make sure I didn't misread the record regarding her testimony.
All right. And I certainly stand corrected, Your Honor. If I have the facts on that one issue wrong, I absolutely will apologize in advance. I also wanted to say that regarding calling the mother as a witness, y'all have, basically already discussed my points. As trial counsel explained, there were 3 people in that room and the mother was one of them. And I think failure to call her would have been malpractice, frankly, or ineffective assistance.
But you agree that the execution was a real swing and a miss, right?
She was a difficult witness, and people, attorneys.
Well, counsel, look, the counsel didn't even ask the questions.
He did miss a question about the child's medical condition, but the child herself admitted to it. So, the victim herself admitted that she was having those problems. So there's just no prejudice at all with her decline, with trial counsel missing that question. It was already a matter of fact out of the victim's own mouth. So,
well, what about eliciting the guilty plea on the exact same incident when the state wouldn't have been able to get that in front of the jury?
Trial counsel explained that was his strategy, that he wanted to elicit sympathy for this witness, that she was, that she had to plead guilty to take a plea bargain, that she continued to proclaim her innocence as well as the appellant's innocence, even though she was serving time. So if there was any point in time in the proceeding that you would finally decide to own up to something that you did, that's it. His strategy was to garner sympathy from the jury based on that witness's circumstances. I would submit that that's not an unreasonable strategy, given the fact that you don't have an awful lot to work with this woman to begin with. I don't think that she was that bad of a witness. I reread her testimony, and of course, during cross-examination, the state was able to bring out some inconsistent statements, but it seemed like that she just answered like any other witness would. She remembered or didn't remember, or didn't recall or did recall. So I would like to talk about the big picture here, if I could, for just 1 minute. Trial counsel's closing argument, it was concise. It tied up the evidence in favor of the appellant. He made 7 major points, tying the evidence or the lack of evidence and arguing reasonable doubt. There's been some discussion in the briefs about counsel promising that they
counsel, your time has expired. So
okay. Well, I would invite you to read trial counsel's closing argument, which again succinctly summed up the evidence in favor of his client and argued.
Okay, thank you, counsel. Your time has expired. Mr. Foreman, you may proceed.
Thank you. I know I don't have a lot of time left, so I'm going to talk quickly before the text message. We address that. On page 917 of the record is the deposition of the state's expert. She says sexual abuse took place. This expert in no way, shape, or form ever said anything favorable for the defendant. When defense counsel tells the jury that it's as likely that she received those injuries from scratching as from sexual abuse, that's a misinterpretation of her deposition. That was nowhere to be found. Even on page 728 of the record, the closing argument made by the prosecutor says that literally says that the state's expert went toe to toe with defense counsel and she was unequivocal. That's on page 728. She never said anything that was beneficial towards the defendant. In fact, when the defendant said, asked her about situations where children may lie, she threw a haymaker and nailed it. She said, "Hey, I've never seen a lie with these type of injuries." And the expert, defense counsel specifically admitted at the evidentiary hearing that the defense expert or the state's expert never said that the injuries were from self-scratching. Now, as far as the text messages, there's two important
Just
admissions.
highlight the prejudice, counsel, of the text message not coming into evidence
Okay.
briefly.
I think defense counsel's own words at the evidentiary hearing sums it up. Page 1084 of the record. First, he admitted that he assumed it would come in, told the client it shouldn't be an issue. But
What's the prejudice?
Okay, here's the big ticket item, Your Honor, page 1058. He explained at the evidentiary hearing that without the text message, he did not have an explanation as to why the child would lie. That's exactly where the prejudice falls. And how do we know that? The very first
Yeah,
thing
but
he
the
said-
text message wasn't going to come in, right?
Correct.
So, where's the prejudice? The text message wasn't coming in anyway.
Correct.
Either way. So where's the prejudice? That's what I don't understand.
The prejudice is an opening statement he commits to within the very first paragraph on page 434 of the record. He says this case comes down to two questions. Number one, why would a 14-year-old girl fabricate a story? And two,
He shouldn't have highlighted that in openings.
correct.
Okay.
But then we go to closing. Page 711 and 721, he says, why did BR lie, or the victim? I don't know. I'll never be able to answer that. None of us will. Tie that with his mission on page 158 of the record, where he says, without the text message, I have no explanation as to why she would lie. That guts his entire theory of defense. And of course, the prosecutor at trial on page 725 said, hey, he brought up a good point. Why would they lie? Why would she lie? She got nothing against him. And I see my time's up. Unless there's any other questions, I respectfully ask the court to look at this cumulatively and grant a new trial.
All right. Thank you, counsel. And we will stand in recess.
Thank
Have
you.
a great day.